Mr. Scott, 7 minutes, please.
Thank you, Mr. Chair, and thank you, Mr. Kingsley, for coming, and thank you for an extremely detailed, contextualized presentation. I appreciate that you've been very fair in commenting on some of the positive aspects of the bill, categorizing some other parts as neutral, but you've also very clearly indicated some problems that I think you obviously would like to see fixed. And frankly, I may be understating that, because at the beginning of your remarks you indicate that you seem to largely be in agreement with Mr. Méran on many of his concerns. So what I would like to do, if possible, is just to double check and ask whether there's any elaborations you'd like to make on some of the concerns you've expressed. One of the things is you've expressed that Section 18, as now modified, that is getting rid of public education outreach functions and replacing it with the targeted list of communication functions, that has to absolutely be repealed and the current provision put back in place. That seems to be what I heard you say. So I do know that back in 2006 in your report you talked about quote, Elections Canada was also able to conclude landmark agreements with various Aboriginal organizations to generate stronger interest and participation in the election among First Nations, Métis and Inuit electors, unquote. And I've taken the time to read a lot of your work over your tenure, and to me outreach and public education and enhancing general participation in elections was hugely emphasized. So with that, am I right in thinking that you think getting rid of Section 18 is a very large mistake?
I've categorically stated Section 18, in my view, must be totally repealed from the proposed legislation. And if I may, I'm very pleased that you're raising the whole issue of Aboriginal electors. We were able to achieve Canadian population, which had been slowly removing, reducing to 60% participation, actually went to 64% at that election. But Phil Fontaine and I, through efforts, we were able to trace that for Aboriginal electors, especially from First Nations, the increase had been 8% through efforts that had been deployed. And who knows where we would be if there had not been those efforts with respect to the young people. Would we be at 33, 35? Would we be at 41? I don't know. All I know is when you're the Chief Electoral Officer, you know you have a job to reach out to groups which require special efforts to be deployed by the electoral authorities. This is the only way one can visualize that job.
Great, thank you. If I could now move on to the interconnection between the new voter contact services regime and the investigative powers of Elections Canada. My colleague, Mr. Lukivsky, asked you a question about the new voter contact services registry, and I think your answer was that it will help, and I can't disagree. The problem is whether it will actually make us too complacent, because there are still things that are not either in it or connected to it. So the first thing is, am I correct in hearing you say that the 1-year period for retaining data on the part of the telecoms, the voter service companies, etc., is far too short?
Far too short.
And the second thing is that Mr. Méran pointed this out, that it's rather inexplicable and a problem that phone numbers do not have to be retained. Did I hear you say that?
Those are the two matters that I raised that your committee should consider very seriously introducing into this bill.
Right.
Especially the prolongation. To hold records for 1 year simply does not do it. If you consider that parties take 6 months to file their reports, Elections Canada then must do its audits. Not all reports are audited in 1 day. This can take several months. Now, if there's anything wrong, after you've dealt with the party to and fro, you then have to refer this to the Commissioner for Investigations.
Right.
Okay, and then that has to be referred to the prosecutor. 1 year doesn't do it.
Okay. And I'd also point out that something Mr. Méran had mentioned in earlier reports is that the shorter the period, the more you need a power to go to the courts to ask for documents to be retained once an investigation is underway, and that power also is not in the bill. My concern is that, and I had my own private member's bill on this, and I was under no illusions that it would solve the problem of truly rogue operators doing automated calls using proxy servers and burner phones, not even using the services of legitimate voter contact companies. And there's nothing in the regime that will actually tackle that problem. And the only solution I see is you must beef up the investigative powers of the Commissioner for Canada Elections. Two things are missing, one in particular. The power to compel witnesses, along with requisite safeguards for their rights. The other thing is the access of the Elections Canada to National Party documentation supporting their expense claims. Neither of these has been included in the bill. I understand that you, in your remarks, as I was listening, you said both of them are still needed. Would you agree with me that without those powers, the ability of Elections Canada, or Commissioner, if he's now in the DPP's office, to actually get to the bottom of the more serious forms of robocall fraud, the ones that don't even use the existing legitimate system, without those two powers, it's going to be very difficult.
Well, I would submit to you that even with those powers, it'll be very difficult. There are people who want to cheat. It's as simple as that. They're few and far between, but they're there. But obviously, it would help if those two powers were included, and that's what the gist of my remarks were in my recommendation to this committee, to consider them seriously before not including them.
Great. And just for finishing this this round of questioning, I did understand you to say unequivocally, and I want to make sure I heard correctly, that the practice of vouching is at some level the last constitutional safety net for the right to vote, and that it should be retained. Is that a correct interpretation?
I'm saying that vouching is an essential ingredient of our system, that it is very well protected under our present system. One can easily understand why there are concerns. The lacking documentation. Solve the lacking documentation issue. You know, deputy returning officers are very busy on election day. They see a lineup of people, and they see people who need to be vouched. They recognize the people. They know that they're there with their brother. Okay, you can vote. Forget the documentation. I've got 20 other people in line. This is what happens in the reality of things. They now have to produce bingo cards. They now have to check ID. They have to check residence. These are all things that were added without any consideration by your predecessors on this committee when I told them that they should consider adding people at the polls, which is now being done. Now being done. 2006, I sounded the bell on that.
Thank you, Mr. Kingsley. Mr. Lamoureux, 7 minutes, please.
Thank you, Mr. Kingsley. Welcome to the committee. I do have a number of questions I would like to get on the record for. Number one, let's go back to the ability to compel. You state that Bill C-23 would certainly provide longer reach and sharper teeth. Interesting choosing of wording, I thought. Should the authority to compel testimony be granted to the Commissioner of Canada? Without the authority having the ability to compel a witness, we would argue that the legislation, when a violation has occurred, is going to in fact get weaker, because those individuals, now it's becoming even that much better known that if you don't want to say anything to Elections Canada, you don't have to say anything to Elections Canada. And many independent election authorities today across Canada already have that authority. So we were asking in the past that in fact this should have been brought in the form of a change to allow Elections Canada to compel a witness. Clear statement from you. Do you not concur that having the ability to compel a witness would in fact directly help assist in getting prosecutions for things such as the robocalls?
Short answer is yes.
Good, I'll satisfy that. Regarding vouching, when we talk about vouching, in reading your report, you indicated that obviously it's important we continue on with the vouching, and I'm very happy to hear that. It's something in which we support. There needs to be an ongoing vouching taking place. It seems to me that, is there issues that you have around vouching in some ways, and that in fact what we really do need is to retain vouching, maybe look at ways in which we can improve it, but definitely keep it. Is that a fair assessment of your position on it?
I have no problem whatsoever with vouching the way it is structured under the Canada Elections Act at the present time. And I am suggesting that if the committee wishes to go further, the oaths that are taken should be in writing as opposed to oral, with documentary evidence only being filled out by deputy returning officers and clerks.
That's right. So your advice is if you're going to fix it, go ahead and fix it, but just don't get rid of it.
Please do not get rid of it. 120,000 Canadians.
I respect the plea, and I hope we won't get rid of it. Hopefully that'll be an amendment. On it, you also indicate, let me be clear, and this is quoting directly from you, absent the rescinding of the proposed Section 18 of C-23, Canadians will lose their trust and their confidence in our elections. You're stating that this is not acceptable. What is it you're referring to? This is the Chief Electoral Officer's ability to communicate with the public without limitations. Obviously, you're really concerned about this. And then you conclude by saying, with these changes to C-23, that there is potential, right? Are you saying then that if the government does not make the type of changes that we just made reference to, that this is a bill that really should not be passed by the House of Commons?
That is a judgment that I shall have to reserve until I see what the changes are that you, as a committee, succeed in convincing the government about.
Right.
Then I will not hesitate to pronounce myself.
Right. You had heard, you had followed the proceedings when Mr. Maynard was here, and he was actually fairly clear in terms of the damage that this would in fact cause, even on, not only in terms of the changes and the manners in which the changes were being imposed, no real consultation was done with other political entities, stakeholders and so forth. We now have international community that's looking at it as saying that this is just wrong, the way Canada's proceeding with this. Do you believe that the government has a responsibility to kind of maybe put things on hold, acknowledge that there's a need for changes, and if they're not going to agree to those changes and start looking to how they're putting into place the changes, that it's really to the detriment overall?
There is no way that I can visualize any limitation on the Chief Electoral Officer's capacity to express himself or herself to Canadians about any matter which he or she considers important.
So just given your response, the proceedings and so forth, what would you rank it today? Like when you said A-, was that more so believing that there's going to be amendments brought forward? Can you just provide a quick comment on that?
I rated the bill. You saw the positive elements that I've underlined.
Yes.
And that is what I did. Insofar as any other rating, I'm waiting because the minister has clearly stated that he wishes to move it up to A+. Let us see what is done to move it up to A+ by the government and by the minister.
But if they don't do any changes, are you still going to give this an A-?
If they don't do any changes is a theoretical question. I will address it when it is a reality.
I'm glad to hear that. I'm going to give you a quote that was said yesterday in the House of Commons. It was, in the 2006 election, I was called personally and offered hundreds of voter cards that had been left in apartment buildings and so on. Like an idiot, I said, no, we don't do that sort of thing. I should have said, yes, come on down, and had the police waiting. What would you advise a member of Parliament if they actually received that sort of a call? What would you advise a candidate in an election to do?
I'm afraid that I don't know exactly what the context was where you're quoting, so it's very difficult. I mean, I would not want to react artificially, superficially to something, and I don't understand the context in which a remark was made.
Okay. Let me go back to the idea of what we're talking about is Canada's election laws. And there's jurisdictions outside of Canada. One of the questions I had posed to Mr. Maynard was the fact that when he goes out and abroad internationally, what does he have to say about the current process? And he wasn't very pleased with the current process. Can you provide a comment in regards to the process that we're going into? For example, we had suggested that it go across Canada, that we just don't be here in Ottawa. Let's listen to what other Canadians have to say, that there should have been some sort of consultations done with opposition parties. Do you not think that this is a fair thing to be requesting?
Well, I don't want to comment about the process that was followed to bring the bill forward, because my successor has done that. That is obviously the perspective of the Chief Electoral Officer in position, and I don't want to be commenting on that, okay?
Thank you.
For the simple reason that he stated what he had to say about that.